Hey, it's James, Father's Rights and Resources, hashtag how I got custody. Somebody came across my page, made a comment asking about me doing a video on vacating a protection order. So first and foremost, if I got a protection order against me, I'm doing a motion to reconsider. In some states, the deadlines are different. Florida has no deadline. California is 30 days. Most states are 10 days. Some are 15. I would do a reconsideration first. There's a better chance of winning a reconsideration, in my experience, than a motion to vacate. But if you're past the I assume the person who asked the question is past the reconsideration time. Most states, you don't even have to do a motion to vacate, though. Like in Washington, if you go to the court's website, courts.wa.gov, there's the section that talks about, you can click on court forms, and there's a section on restraining orders or protection orders. And there's a motion to terminate or modify a protection order. Most states have a procedure where you can go back and modify or terminate, which kind of gives you a better chance than a vacate, because vacate, most states, the vacate rule is under Civil Rule 60, or there might be, Code of Civil Procedure 100-60. They adopt the federal court's civil rule numbering system, but they put it under a it's like a sub number under a different chapter or whatever. So you got to know the rules on vacating. And a lot of times it has to be like clerical error, fraud, or any other reason that's extraordinary. You can do a motion to vacate a default because the courts are all about winning an argument on the merits. If you lost by default, you never got a chance to have your say in court. So it's kind of extreme to have you lose by default or by forfeit. So they allow stuff to be vacated. That's the easiest vacate to win, or if there's due process violations. Now, don't start talking about all the child support is fraud, numbnut idiots who say, oh, you're due process because you didn't get notified. In child support, they've created laws and rules that say if you were mailed the child support notice at the last known address, that's due process. If you didn't get it, that's your problem. They've bent over backwards. They got laws in place, and nobody appeals them all the way to the Supreme Court of the United States, so they don't change. So I'm not getting into those numbnut retarded idiots. But if there's crazy due process stuff like you didn't have your fundamental fairness doctrine, you didn't have a right to speak, you didn't have a right to prepare a defense, and with a fair amount of time to do it, you got railroaded, you weren't actually served something that the judge looked at, and you didn't get to see it, and the judge didn't care, and they said it on the record. There's cases like that where I've seen that stuff undone. It has to be something extraordinary. So I would look to a remedy other than a motion to vacate first, because a motion to vacate is so hard. Then, if you're stuck with the motion to vacate as the only option, you need to know Civil Rule 60. You need to know how to look up case law to find how much more detail there is as far as reasons to vacate, because case law will elaborate on motions to vacate way better than the rule itself. Sometimes the rule is there was fraud or there's misconduct from the other side, and that's the only rule, and that's hard to prove. But if you have the procedure like a motion to terminate or modify a protection order, that whole procedure, you don't have to get over the hump of proving an extraordinary circumstance or fraud. You just go in there and you have a wide open door to have a full-blown proceeding and kind of get to relitigate it, or there's some new circumstance, or you found out the person lied, or after the hearing a month later they said, ha in the text message, I lied to the court, and they bought it hook, line, and sinker. That would be a reason to, undo it. But I would want to do it through another process other than vacating. So as far as vacating, you have to follow the rules. And most of the time you have to get an order to show cause, just like you would for contempt or a restraining order. If you don't know what an order to show cause is, you go to the emergency courtroom, you get an order for the other side to come to court and show cause or show a good reason why I shouldn't get what I'm asking for. It should really be, in Washington just changed our language, called an order to appear in court. Actually, it says order to go to court. They changed the language from order to show cause to order to go to court, which is kind of the plain language. They should make it simple and easy for everybody to figure it out and not have a whole new Elizabethan English sounding type of language. They use a lot of Latin words. So you get an order to show cause for the person to appear, because when your case is over with, if you want to start a new case, you have to send somebody a summons. That's their due process right, to be summoned and personally served. A summons. An order to show cause is like a mini summons that's just for a motion. You're not starting a whole new action that takes you all the way to trial. You're just doing a mini quickie motion on one topic or one issue, like contempt. Motion for an order to show cause regarding contempt. And someone is served an order to go to court. If they don't show up in court, they can issue a bench warrant for their arrest. I got one issued to me because I didn't show up at contempt. But I never got served it because the judge emailed me at my last known address and did a favor for the mother to notify me of the contempt hearing, where we hadn't been in court for like about 7 months, and I had a different email address. So, you have to go through the rules and procedures of doing a motion to vacate. Now, the only thing that I could lend is the stuff that I've already said before. When you're talking about restraining orders, and there's Harvard law professors, there's attorneys, there's judges, there's investigative journalists, there's process servers and other PIs and investigators who have all said that women lie about domestic violence and abuse all the time in order to get leverage, in order to get a restraining order or a protective order, to get leverage in the custody case. So women lie more often than they tell the truth in this stuff. That's an argument I would always use. But if you go in there and say, well, she's lying like most women do, that's a bad argument because you're saying it all by yourself. You should go out and find a bunch of quotes from a bunch of people. And I give you a freebie right off the bat in my flow page. In my flow page, which is linked in my TikTok bio, in my Instagram bio, it's under every YouTube video, it's in every Facebook post. There's my flow page, which has a bunch of free resources in one spot that only 5% of guys ever look at. Because 95% of guys are too lazy, shiftless, dumb to say, oh my God, this guy won in court. Maybe I should listen to him. Maybe I should check out some of his free resources. My life with my kids is on the line. I'm spending tens of thousands of dollars on an attorney. If James won in court, he must know something I don't. Let me go check it out. But 95% of you won't ever do that. That's why I get frustrated, because my gender doesn't give a shit about their kids enough to fight, do their own research, or look into stuff. Because we're a bunch of lazy bums, and we're feminine or soft, and we're not warriors when it comes to this war. So one of the links I give you, or you can just search it yourself on YouTube, Divorce Corp False Abuse Claims. In that 1 2-minute video, there's one video that's 2 minutes long. It's a trailer, and there's about 7 or 8 of them for the documentary Divorce Corp. That's the best documentary that's ever been done on the family court system. It was done 15 years ago, and nothing has changed, which just goes to show that awareness doesn't mean jack shit. And you guys are so hard up for like, let's create awareness, let's share with people. I had a guy who came on my page and said, or he was on another page saying nobody's talking about family court. Everybody's talking about it, just nobody's doing anything about it. Then this numbnuts was pissed. You don't know my life. I don't need to know your life to realize, I don't need to know your life to know that you made a stupid, jackass, ignorant statement and lied, and I'm correcting the lie. So if you go to Divorce Corp's 2-minute trailer, it quotes a Harvard law professor, a celebrity judge, and a couple of attorneys saying how women lie all the time about this stuff. If you go in there and tell a judge, hey, look, your own peers say that women lie all the time. That's what this lady did. And it's really sad because there's women out there we know who are scared to come to court. And this lady comes to court and uses domestic violence or child abuse as a punchline. She's making a mockery of real women victims. She's making a mockery. Judge Judy once said this, and that made me think of this stuff. Judge Judy said to a woman, you're making a mockery of all the women who fought to put protection orders in place by coming in here and lying about your boyfriend. Judge Judy is great at exposing women in family court issues. But see, a lot of you guys have seen that video. But there's a million dads who've seen that video. 99% of them are such a bunch of stupid punk-ass mother effing bitches that they never use what Judge Judy said in court because they're too much of a pussy. Oh, that might piss off a judge. A judge said that. Judge Judy is a judge, you retarded idiot. You're letting your fear dominate and control and prevent you from doing anything. So, that being said, you should find as many resources as you can. Now, I have a defense against protection order packet in my store, which has about 30 quotes of different people and great arguments to defend against that. So that's my little quickie on motion to vacate. Get a counsel.